Hello everyone, I'm Kranti from PILUPU TV. Today's hot topic is immigration. There has been so many policy changes on immigration, and we are here at BBI Law Group with Mr. Bhanu B Ilindra, and he will give us more details on this. And then we'll see how these policies are impacting our communities. Hi Bhanu Garu, how are you doing today?
I'm doing great, Kanti. Thank you very much.
So you must be really busy nowadays with all these immigration policy changes. So we are here to get to know all these policy changes regarding H1B and H4 and see if you have any suggestions and guidances for our communities.
Sure, Kanti. I'm very happy to give my advice. Whatever I can do for the community, I'm here for that.
Okay. So let's get started.
Mhm.
So recently there has been H1B policy change, and what exactly is the change and how is it going to impact for people who are on H1B?
Mm-hmm. Kranti, recently, on February 22nd, USA has issued this memo, right? And it's an education policy memo. Basically, that memo actually gives a guidance to the USCIS officers how to adjudicate H1B petitions and everything. In that policy, basically, they basically gave more clarity on what kind of evidence is required to adjudicate H1B petitions, especially when employer places their employees at the third-party client sites. Okay, that clarity is basically they talked about the type of evidence is required, what kind of a standard of burden they have to prove for the ordinarily to the USCIS, what to be presented, what not to be presented. That's what this policy memos, gist of the policy is that.
So do you think it is impacting mainly the people who are on contract positions, or is it going to impact people who are on full-time as well?
This policy is mainly concentrated affecting the people who are on the contract positions, especially people who are working at the third-party client sites. Full-time position means also can vary sometimes because full-time employees also can work at the third-party client sites when they have a direct contractual relation with the end clients, basically. So it's going to affect all the individuals who are basically working at the third-party client sites, either through the employer-client model business model or employer-vendor-client model business model. So it could call EC or EVC models, basically. Either one of those models, basically, who the employees are providing service to a third-party client site, third-party employer, rather than the actual employer who's actually their employee, their employer, then this memo is going to really impact a lot.
So follow-up question on that, right? What are your suggestions for employees and employers in order to get a favorable decision on H1B?
Okay. As per this memo clearly acknowledges the third-party client employment relationship is a legitimate business model.
Okay.
That means they're telling that all these consulting companies can continue filing their H1Bs, especially if their employees working at the third-party client side. So what this memo gives is more clarity. They're telling that what information is required for them to determine whether the employee is working in a position offered, which is a specialty occupation, and also there is a valid employer-employee relationship exists between them. I think this memo is actually, so it's an employer and employee has to ensure that they document that properly. They show that there's a valid employer-employee relationship exists, even the consultant working remotely at the third-party client site. That means they have to document the process through which they control the job of the employee, or how employee basically reports their daily day-to-day activities, what they have done to their employers, and how employers supervise the work of the employee at the third-party client side. That is one aspect of that. Second aspect of it that is basically is we have to establish the position qualifies as a specialty occupation. When the position qualifies as a specialty occupation, basically, especially when the layers are involved in between in the employment, like if it's an employer-vendor-client model, how we are going to establish the position as a specialty occupation is by establishing the contractual relationships between all the layers involved in between, and the language in those contracts will determine whether the position qualifies as a specialty occupation or not.
Okay.
So US is clearly telling that those contracts and the work orders in between should have a clarity and should describe in detail what the job duties are, what the position requirements are, what are the education requirements are, and those things are very, very important.
So follow-up question on that one, right? So there has been we already have to establish the employee-employer relationship and even in the contractual situation. What exactly changed in this scenario?
In the scenario is basically what they're telling is the type of evidence you require to provide. Previously, they used to approve those cases based upon certain type of evidence you presented to them. Now they're telling that the evidence which you're giving in the past may not be enough to get these approvals anymore in the future. They're saying that along previously, for example, if we have to get an approval in the end client model, basically third-party client model, usually the contractual requirement, I mean, to establish the employer relationship and also to establish the itinerary and the position requirements usually is sufficed by providing just the client letters to them, right? We don't have, I mean, most of the times employers don't provide the contracts because end clients and the vendors, sometimes they don't like to provide the contracts because of the confidentiality issues or their personal company policies, whatever they are. But they try to substitute, they try to suffice that requirement by getting the letters from the end clients and vendors and all those things. Now they're telling that just those letters may not be enough. They would like to see these contracts. They'd like to see these work shares orders. They would like to see these documents and everything. And also, previously they said that itinerary requirement is a very generic in nature. The employer can tell that you, the consultant working at this third-party client from this time to this time and all these things. Especially, but now what is telling...
Question on that one, right? What are these itinerary requirements?
Okay.
Could you please elaborate on this?
Sure. See, whenever, I'm sorry, I might have jumped the guns before you asked me this question. Right now, I'm glad you asked that question so we can go with more clarity on those issues, basically. When the itinerary requirement is basically, that's required by law, by INA, Immigration Nationality Act. Statute requires when an employer is basically hiring an employee for a contractual purposes to a third-party client side, then employer is required to provide a definite itinerary for the employment duration of the employee. That means basically for the duration employee is working, the employer should provide itinerary for how long he's going to work, where is he going to work, and what are the time schedules, and all those things employer has to provide. And especially if reporting to the third-party client side, basically. So in this scenario, what they're telling is basically is that if the employee working at the different multiple locations at the same time, if for the duration, then that means basically if the employer is showing that he's going to work for this particular client, this client, that client, client A, client B, client C, basically, then employer is required to provide the timelines. How long is going to work with the client A? How long is going to work with the client B? How long is going to work with the client C? What are the schedules with the client B? What are the schedules with client B? What are the schedules with client C? They require the employer to provide that in detail with the H-1B petition. If you don't provide that, especially in multiple location scenarios, multiple client scenarios, then you might have a problem with that.
Okay.
And yeah.
So question, so if there is only one client, is it still impacting the policy, or is there any change in the policy?
This policy impacts even if there is one client also, but itinerary requirement may not impact, basically, because irrespective whether it's one client or two clients, multiple clients, you're still going to provide itinerary. The itinerary can be provided in various forms. You can provide a separate annexure as an itinerary, or a separate addendum as an itinerary, or basically you can provide in the statement, employer statement, what you're attaching with the USCIS, responding to the USCIS for seeking your H-1B petition. In that statement itself, you can provide the itinerary of the employee, exactly what the employee is going to do, how long he's going to do, and everything. And or you can also document the itinerary through the purchase orders, work orders, and the client letters from the end client. Though through that way also you can establish the itinerary, basically.
Okay. So this requirement, was it not there? Was it not there before?
It was there, as I said, it was there always. But now they're telling that they need in certain format, especially when the multiple client scenarios for the requested H-1B duration, they want it in a particular format, and that's what they're basically telling that basically. And not only telling the itinerary in a particular format, they want the evidence also substantiating that itinerary, basically. That's what they're talking about.
So when you say evidence, what kind of evidence, and then how hard is it to provide this?
Yeah, I mean, in practicality, it's very hard. Reason, as I said in the beginning, especially in the EVC model, where employer-vendor client models or employer-client models, where what happens is basically is that clients may not be willing to provide all the documentation to the third parties, like a USCIS or any other party, any other entity, basically. Reason why they will not be willing to provide those information is because of the confidentiality issues, business secrets, trade secrets, whatever you call them. Because some employers, some companies might be bidding certain level their services. These companies may be bidding services at different level, and that basically kills the competition for them.
Okay.
Basically, and they want to keep their own identity, their own business secrets, how they're securing their business and everything, as per their project requirements, bidding requirements, whatever they are in. So clients would be very hesitating to provide those documents in practicality.
Okay.
And if the USCIS mandates that the client they have to provide those agreements to get the H1B approvals, that means you're automatically seeking the denial if you're not providing those documents, basically. So that is the impact which this memo is going to happen. They have given a list of the documents, what is required to respond to the H1B RFEs, basically. And those documents basically clearly says what documents are, and also they say that what these documents should contain inside also. It is not like they said that just we need these documents, like what it has been stated previously in Newfield memo in 2010 to establish employer-employee relationship. But in this memo, they're clearly telling the officers to look into what information is required basically to adjudicate these petitions. Basically, they're telling the officers, when you're adjudicating the petition, when they provide the documents, in those particular documents, you look into this particular information to determine whether there's a specialty occupation available and a valid employer-employee relationship exists.
So, question on that one. If it is hard to provide that kind of a documentation from the client, what kind of advice are you going to give to the prospective employees and employees? Still,
it's not a dead end.
Okay.
Still, you can provide various alternative evidence, basically.
Okay.
And if the client is not willing to give the contracts, you can provide by the technical documentations. You can provide the project milestones, basically. You can provide your RFE bidding information. And basically, RFE bidding information clearly shows exactly what positions you are bidding for, what technical specifications you're bidding for, and everything. And also, you can provide your client requirements. When you're placing the candidate, you must have got the requirements from the client.
Right.
And those requirements can be shown, how technical they are and everything. What are the minimum education requirements required for those positions? There are various kind of documents you can provide that.
Okay.
And we would like to usually give a one-on-one advice in these issues, because every case varies. Every individual case varies. Every petition varies.
Okay.
So if your audience have any questions about those things, they're welcome to contact our law firm, schedule an appointment with our law firm, and we are very happy to discuss with them in person.
Okay.
And that's what it is, basically.
Do you also have a call, like a webcast kind of a call going on every week?
Yes.
To address these questions?
Yes, we do. Every Tuesday evening, we have a call from 7 p.m. to 8 p.m.
Okay.
This call conducted exclusively by BBI Law Group.
Okay.
And we get support from various sponsors. Sometimes with your TV, PILUPU TV gives us support. Sometimes some other organizations, non-profit organizations, give us a support, and all those things. But every week we are conducting the calls, 7 p.m. to 8 p.m. And also we have every week, every day, we respond to the questions posted by the people in social media, whether it's online or by email, whatever it is, from 10 to 11 a.m. in the morning, and also again in 4 p.m. to 5 p.m. in the evening.
Okay.
Twice we are responding to those things. We are trying to contribute ourselves. We're trying to provide all these services pro bono, actually. That means for free. That's basically taking around 11 hours a week from my end. And I'm trying to do whatever I can do for our community to get the legal advice. I know that sometimes it's very difficult for them to go to a lawyer and discuss. It's not that they cannot afford it, but sometimes it's time crunch.
Yeah.
And we try to understand that.
That's very nice of you to provide these kind of services to our communities.
Yeah. Thank you very much, Franti.
So, a follow-up question on the same H1B, right? So, how is the new policy impacting the H1B extensions?
The H1B extensions are impacting the same way, as I said, for all these factors has to be considered when filing an H1B extension also. And also at the same time, they have to ensure that they have to make sure that the employee was maintaining proper valid status at the time of filing H1B extensions.
Yeah.
And in order to determine that, there is various factors they look into, right? First is whether employee has been paid proper wages, whether employee has been paid proper working conditions that are same or similar to the US worker.
Sure.
And third thing is basically is whether if the employee changes the project, whether it's properly filed timely amendment or not, and where the payrolls have been run, whether they're running at the place where the employee is working or they're running at the place where the employer wants to run. Okay. These are small issues can pop up a big time in H1B extensions. along with all these issues what we discussed right now.
Okay.
Because these things will be applicable. These are applicable for any type of petition, whether it's an extension, whether it's a change of status, whether it's a transfer, whether it's an amendment. Doesn't matter basically.
Sure. So now let's switch to H4 situation. So
Okay.
what is the situation now, and then do you think H4 EAD is still going to exist, or is it going to be cancelled?
The current administration clearly said that they're going to cancel the H4 EAD program. The reason is because it was basically regulated based upon the executive order given by the previous administration. And the current administration is very much believes that previous administration have done some things beyond the law. Therefore, they would like to cancel the H4 EAD program. However, there's a case going on that has been filed by some non-profit agency saying that H4 program is not proper and appropriate, but they could not win the case at the lower level, and it has been appealed to the higher level in DC basically. In that, it's pending now in appeals court in DC basically. Now the government, while this case is pending, the government has been changed, and obviously Attorney General's office has been changed. The current AG office is not showing that much interest to provide any arguments that is against the plaintiffs basically. So they are basically in collide with the plaintiffs. Basically, they want to cancel this program and everything. Therefore, in the recent hearing, which happened like 4 or 5 days ago, the AGO office clearly said that they would not like to make any arguments, and also they would like to introduce a policy, notice and comment policy, buffer for canceling the H4 EAD program. By law, they have to follow the process under the APA, which is Administrative Procedure Act. They have to provide a notice and comment for any regulations that needs to be either repealed or to be established, basically. Okay, and so because of that, we're expecting that some kind of a notice will come from the current administration, stating that they're going to repeal the H4 EAD program. They're going to cancel the H4 EAD program, and they'll be given all the people will be given 60 days to comment in favor or in against the H4 EAD program, and based upon that, they will formulate a rule. And this process will take around, I would say, all these things going to happen. Even if you assume that they're going to put a notice end of this month or early next week, the notice and comment period is 60 days, and then they have to formulate the policy and everything. So my assumption is nothing happens before August or September, even if they have to cancel at that time.
Okay. So what kind of advice you have for H4 EAD, people who are already working on H4 EAD?
See, one thing I would say is this: if you can file for H4 EADs right now, you file for it right now, because if you file for it, if it gets approved, you'll have EADs for 2 years. So my assumption is that even if they cancel the program, they're not going to cancel their EADs. Their EADs will be valid till that period for which it has been approved for. After that, they cannot extend their EADs, but they can work till that time. This is what we have seen when they canceled the DACA program in the past. Although now DACA program is still is in place as it is because of the injunction given by the 9th Circuit, and the Supreme Court said that they cannot do that. But when they implemented the DACA program, what they said is basically is that the individuals can continue using their DACA EADs until they expire. So I'm assuming that they will do the same thing with the H1B, with H4 EADs also. Other option is basically I would advise them, because caps isn't starting, H4 EAD H1B caps isn't starting. If they have an opportunity, if they have an employment, I would advise them, if their EADs are getting expired in the next 6 months, 7 months, and if they think that they cannot apply any EADs prior to the rule coming in, or prior to the new regulations coming in, if they have an opportunity, ask them to file H1Bs in the cap season, and hopefully their cases get selected in the cap and they get H1Bs.
Okay. So let's switch the topic to green cards. There are so many backlogs in green card processing. What is your expectation? Do you think that's going to go any faster?
As I said, people might think that I'm trying to pull a rabbit from the hat, basically, but actually there is some positive news and negative news, basically, in this issue, basically, right? See, everybody in AILA, we lawyers, immigration lawyers, we follow visa bulletin very strictly, basically, and we basically try to assess how the visa bulletin is basically prepared and how the visa numbers are issued every month and everything. And in that way, basically, AILA recently had a meeting with Oppenheimer, who was basically responsible for this allocation of visa numbers in the Department of State. And as per him, basically, that there's a lot of there is a lot of hope for the EB2 members to move forward for the Indian nationals. Right now, I think it's 2009, I think, but they're expecting that they may move till the end of the 2010 and 2011 in the coming months, especially in May, June, July. You will see a lot of movement going in. And the reason for that is because of the recent adjudication policy by the USCIS, where they said that every 485 applications has to go through the interview process before they are approved and issued a green card. And because of the this process, what happens is there will be delay in adjudicating green cards. Obviously, those numbers will be available to assure the those numbers will be available, and those numbers to be made should be make it open for the next going on days. For example, what I'm saying is if they put 2009 to July dates are available for the current, they made it current. Let's assume that 2009 is current, right? So they will call for the interviews all the individuals before 2009. However, they are not issued any green cards. So because those numbers are not issued, then they have to move the dates, hoping that the next numbers when they put 2009 to 2010, hoping that people in this category will become permanent residents. But that is also may not like to happen because of the process which they implemented. Because that may also may not happen because US has implemented the policy that they have to go through the interview process and then they have to prepare the report and then they have to request the visa number from the Department of State and approve the green card in that way basically. So because of the process, there could be procedural delays in adjudicating these green cards. Because of the procedural delays in adjudicating these green cards, people does not get the green cards. So more visa numbers will be available for the people. If the visa numbers are available, then they have to allow these individuals to file their 485s, right? In that way, the visa numbers will move forward because less number of green cards will be issued to the individuals.
Okay.
Because less number of green cards are issued, visa numbers are available, it's very optimistic that the numbers can move forward from 2009 to 2011.
Okay.
And that's an optimistic view, but I think people should be hopeful for that.
Okay.
Could happen in this year for the EB2 nationals. For EB3 nationals, we do not speak anything. So I'm not sure whether we'll be able to say anything. This information can be found in AILA website. If people can go to the AILA website, they can find this information.
Could you please elaborate on the AILA website?
AILA is American Immigration Law Association website, and it's basically an association more than 15,000 immigration lawyers, and they all come into one umbrella to ensure that immigration benefits, the people who are seeking immigration benefits are properly represented before these agencies. All these administrative agencies, whether it's an immigration code, whether it's an USCIS, whether it's immigration customs enforcement, over they are in basically. Okay. They are the major immigration practitioners.
I have a very basic question, right? How are these green card numbers are decided? How many green cards are going to be issued every year? Would you just clarify for our...
It is all actuarial science, basically, based upon the number of visas issued in the past and also based upon the number of visas have a demand per country limitations for each and every country. And they basically decide, the Department of State decides basically what numbers of visas can be issued or anticipate to be issued in the next months. What is the demand they have? They can anticipate the demand for the visas based upon the country for which the people are applying. And based upon that, they basically do that. When you do that, basically, as you know, per country limitation is 2.7% for each individual from 140,000 visas, basically, right? Actually 8.4, yeah, something like that basically. So because of that, only 8,400 visas can be issued for each country in a year. And those 8,400 visas, basically you have people who are actual beneficiaries and their dependent family members also in that.
Okay.
So in reality, probably employees may be getting maybe 2,000 employees to 2,500 employees getting the green cards because their family members take away the remaining members in all categories, EB1, EB2, EB3, EB4, EB5 categories.
Okay. So, congressional action. Are you expecting any congressional action on comprehensive immigration?
No, I would say no, because I don't know whether there is any, I don't know whether there is any proper understanding between both the parties in the Congress right now. And I think they are very far away from each other. They have to find a middle ground to do that. And I'm not sure whether they'll be able to do anything even for DACA also before March 5th. But now the issue is removed because Supreme Court did not do anything on this issue. But they have enough time now to come together and do something with the DACA fix. But comprehensive immigration reform, I think it's a very long shot.
Okay. So any positive news, whether it could be H1B or EAD or green card, do we have any positive news at all?
The positive news is basically they did declare that the third party client placement businesses like EVC business models or legitimate businesses, they can file for H1B petitions. That is a very positive news.
Okay.
Okay. And second thing is basically is they're not denying H1Bs irrationally, and they're approving them, and they're allowing people to work, move freely and everything. Situation is not that bad as people think. It's just that paperwork needs to be properly done, has to be properly reviewed, properly guided, and properly prepared. All these contracts and everything needs to be properly done. If you do that, I don't see any problem getting H1Bs approved. So that is the situation in this case.
OPT, right? Any policy changes on OPT, and are you expecting any changes in the near future?
No. As far as I know, there are no indications of any changes in OPT policies and regulations. But obviously, you can expect there could be more site visits happening for the OPT, STEM OPT extensions, basically.
Okay.
But as far as I know, there are no policies changes. Everything is same.
Okay.
That's my recollection. I mean, I could be wrong, but as far as I know, there are no policy changes.
Question also. Okay. The next question is like on H4 dependents.
Mm-hmm.
Are there any policy that are going to be taken in favor of H4B dependents who are basically aging out?
I really do not know, but there's a lot of noise going on around. A lot of people calling for a fix for that. It's called DALCA fix. That's basically deferred action for legal immigrants in this country, basically. And so there's a lot of movement is going on. There are some certain congressional statutes. I mean, bills have been introduced in the Congress having some fixes for those things. Hopefully, those things will come up. Everything will properly settle down. And I'm glad that there's some activism is going on in the community, seeking benefits for green lock, backlogs, and fix for DALCA and all those things basically. But they have to be wise exactly what they're asking. They need to have an idea, clarity, and agenda what they're asking, and that should be acceptable to the mainstream America also. And also, their activism should not be in any movement in any way such a way where it will actually be against the American values and principles basically. And they have to respect the American law and obey to that and produce with that. But as I said, as of now, it's just I don't know. Is there going to be any fix or not? Till now, it's unfortunate that if they cannot file 485 before they age out, that means before they cross 21, they'll be out of luck.
Thank you so much, Bhanu Garu, for meeting with us today. I know you are a pretty busy guy, and then you still found some time to talk to PILUPU TV today, and we do really appreciate your service to the community.
Thank you very much, Kranti. It's my pleasure.
I'm sure you have so many questions on today's topics. Please feel free to contact BBI Law Group, Bhanu Ilindra Garu, and then he'll be happy to help you out. And he's also a very good community supporter. He is here to serve the communities. Thanks for watching today's program. This is Kranti signing off. See you next time.